Hello, Judicial Branch. So let's do that. Um, the ju the judicial branch has to do with the court system, state and federal courts. The judicial branch is most known for the United States Supreme Court. That Supreme Court is the highest court in the land. There are 9 justices on the court. And the Supreme Court is the only court that is in the Constitution. All the other courts are not, and Congress can make courts as necessary. Cool. Cool. But Judicial Branch handles the entire court system. What do courts do? They resolve disputes, interpret laws, interpret the Constitution, protect the rights of citizens, things like that. So when you go to court, you have a plaintiff and a defendant. The plaintiff is the person that brings the lawsuit. The defendant is the person accused of the crime or is being sued against. So if I wanted to sue Katy Perry for not being my wife, then I would be the plaintiff and Katy Perry would be the defendant in that case. Now, a court would hear the evidence in the case, review relevant law, review relevant constitutional clauses if necessary, and then render a decision as to whether or not Katy Perry is my wife. I'm sure I would win that court case. The courts that we look at least for this class, that are kind of most important for the basic functions of, like the big political issues that people will be looking at that, maybe you'd want to know for, like being able to properly interpret American government, American politics, which is one of my goals of the course anyway, is to hopefully give people a context, background with which to understand the current events and political decisions before y'all when you're voting and such. Courts, or for the most part, courts will just have a judge. The federal district courts, you'll have a judge, and the judge will make a ruling on whether or not a case has merit, right? So the judge will issue the opinion, say, the plaintiff was right in the suit to bring the suit, and here are the reasons why. You'll have the justification, or they'll say the plaintiff was wrong. Excuse me. And the defendant acted properly. Okay. Federal District Court usually have 1 judge. The 4th Circuit Court, you'll have 3 judges. Most of the time, you'll have 3 judges. And they'll issue an opinion as to whether or not the court wins. Or the decision stands from the lower court, whether or not, which side wins the case. One of the things that I want to impress upon y'all, and this is something to remember with the courts, is that in some circumstances, in some places, not everybody needs to come to the same conclusion. I encourage everybody in the proper times when you're like employed and stuff to make sure you don't involve or get involved in groupthink or have that be your natural tendency to be involved in groupthink, or have the one dominant person or two dominant people in the group, either in employment or in school groups, lead the conversation, sort of make the decisions, things like that. It's okay to have different opinions and to express those opinions and to not be convinced by other people. At some point, sometimes decisions have to be made, and you can lose, and it's okay to lose. But when we do work in the class or whatever, for the most part, I don't expect any group to all have the same opinion or conclusion. Excuse me, it's late. If there are 5 members in a group, I would completely expect that maybe 4 people feel one way and 1 person feels the other way, a different way. One of the things that I like to see is each side, or all the sides, give a couple of reasons why they support their position. They're justifying their position just like a court does. Okay. Make sure you know what the judicial branch's role is in the functioning of American government, the questions that they look at and determine, sort of in a broader sense, is the law or parts of laws constitutional or unconstitutional? Is the government doing its job? Are people's rights being protected? Do we need to extend rights? Things like that. How should laws be interpreted? Is the executive branch interpreting something passed by the legislative branch appropriately? If you look at the bureaucratic slides at the very end of that, there are a couple of questions or a couple of examples that are similar to that. One of the laws, or the founding legislation for the FDA, said that the FDA had authority to regulate any drug that was delivered through a device. Right, so you have a drug, and if it goes through a device, or some like changing process, then it can be regulated by the FDA. Say that's kind of the general setup of it. The FDA decided that cigarettes, tobacco's a drug, and I guess for tobacco to be useful, it has to, or at least cigarettes are a means of delivering that drug, I guess the nicotine in there, to you, and thus cigarettes should be regulated. So nicotine's the drug, the cigarette with its filter or whatever's in there, the burning in the paper is a device that delivers the nicotine, and so therefore tobacco, the FDA had the right to regulate tobacco, to put on various warning labels and blah blah blah, whatever. That was in the mid-1990s. The Supreme Court ruled that the FDA had overstepped its legislative authority, that the legislative intent was that the FDA was never supposed to be regulating tobacco products. There was some other legislation that came up after that showed the intent of Congress was to not have tobacco regulated, to not have certain warning labels put on there and such. And there was a law introduced to make it so that the FDA could regulate tobacco products, but that by the time the law was, the ruling was made, the law was drawn up, it was 2001 or 2002, and we had George W. Bush, who was not about to sign any law expanding the FDA's authority in most ways, especially on tobacco products. So it was one of the first things Obama did, pretty close to one of the first things that got passed, and now the FDA has the power to make sure cigarettes are safe for us. Go team. Okay. Okay. One of the key things to know about the Supreme Court, about federal courts, this also applies to state courts, is this idea of jurisdiction. Courts have to have jurisdiction in a case in order to hear the case. They have to have geographic and subject matter jurisdiction. Geographic jurisdiction is the area in which a court can hear a case. So a court that has geographic jurisdiction in Guilford County can hear cases that originate in Guilford County. A traffic court in Guilford County can hear cases that originate in Guilford County that have to do with traffic violations. Same thing applies with like a federal district court. A federal district court might be like the Federal District Court of Northern California, which is where the Prop 8 case started. Handles court cases that originate in whatever section of Northern California that court had jurisdiction over. And that together is known as jurisdiction. The court system, the important thing with this is the hierarchy. So you have the lower level courts, which are the federal district courts. They render a decision, and then if one of the two parties is so unsatisfied with the decision or has the resources, they can appeal the case up to the U.S. Court of Appeals. Now the U.S. Court of Appeals is divided into 13 circuit courts. It's the United States Circuit Courts. The U.S. Court of Appeals, same thing. The nicknames for each other or whatever. We have 13 circuit courts. One that has to do with certain specialized cases. Mostly you think of like copyright issues. Some financial dealings. But the 12 other courts apply to specific geographic areas. North Carolina is in the 4th Circuit Court. So a court starts in a federal district court if it's in North Carolina. Let's say it starts in the District Court of the Triad. Don't know if that exists, but let's say it's the federal district court that covers the Triad area. If somebody appeals a case from that district, it'll then go to the 4th Circuit Court, which covers West Virginia, Maryland, Virginia, North Carolina, South Carolina. The Circuit Court will make a ruling on the case, and when the Circuit Court makes a ruling on the case, generally that ruling will apply to all states in that circuit court's jurisdiction. So, again, it'll apply if applicable. So, the Fourth Circuit Court rules that police can't search your car if they smell pot in it. That's an unwarranted search and seizure, let's say. The circuit court rules that. Now that ruling, if that case originated in North Carolina, circuit court says police can't search your car if they smell pot. Now South Carolina, North Carolina, Virginia, West Virginia, and Maryland police departments are subject to that court's decision. So if a West Virginian police officer searches a person's car because they smell pot, the district court that first hears the case in West Virginia will most likely rule that the police officer's search was an unwarranted search of a person's property. They could then appeal that decision if they wanted to. The Fourth Circuit Court would look at the precedent they set, the previous ruling they made, and say, well, we've already rendered on this decision, so tough. You can't do this. They could also overturn their previous decision, but depending on the time, that can be rare. Anyway, the Fourth Circuit Court could make their opinion very narrow to apply to a particular case or a particular state. But in general, if something is made legal in one by the circuit court, whatever the circuit court is, it's legal all across that court, across all that court's jurisdiction. So, after you have the United States Circuit Court, you have the Supreme Court. Now, very few cases every year make it to the Supreme Court. Generally, all cases end at the circuit courts, and that's it, because the Supreme Court only hears 100-ish cases a year. The Supreme Court's the final law of the land. Whatever the Supreme Court says, boom, that's it. Game over, case closed, whatever. You may think, well, if the Supreme Court's the final law of the land, if whatever the Supreme Court decides, that's it, that's over. Why do we have a legislative branch? Like, what's going on here? The key thing is, with the whole judicial system, is the judicial system can't just pick up something that they want to rule on. So Congress passes a law saying it's okay to send babies into space to test their reflexes. That's a terrible idea. That's a really terrible thing to do. The Supreme Court cannot step in and say, really, guys, this is dumb, unconstitutional, and it's also dumb. Somebody has to sue the government, or a state has to sue the government and say, you can't be sending children into space or babies into space to test their reflexes. The case would start at a federal district court and it would work its way up, and then the Supreme Court could choose to hear the case. But courts can only take on cases that people bring before them. A court, again, this is critical, a court cannot run out, find a case it likes, or find some injustice it sees happening in the world, and then do something about it. It can't run to Montana and say, y'all guys haven't made gay marriage legal. Well, here we come. We're about to rule and say it's legal. can't do that, somebody has to bring a lawsuit. And it's got to work its way up. So, despite that, or you can say that's a check on the court's power, that the court can't just do anything it wants to. It has to be prompted, have a case brought before it. But if it does, it's the final law of the land. The Supreme Court, just like the Fourth Circuit Court, would set a precedent for its geographic area. The Supreme Court sets precedents for the entire nation. Generally, that means that federal district courts and circuit courts are obliged to make future decisions that are on similar cases or on the same case that the Supreme Court had previously ruled on. You know, say the Supreme Court ruled on this and that's the decision. So it wouldn't be, you know, exactly the same case. So we got your pot example. North Carolina, it goes up to the Supreme Court. They rule that you can't search a car just because you smell pot. They ruled that in 2008, let's say. In 2011, a person in California gets pulled over and the officer smells pot and they search the car. That guy decides to file a complaint and do a lawsuit and etc., etc., etc. When it gets to the Ninth Circuit Court, if it even gets that far, gets to the Ninth Circuit Court, the Ninth Circuit Court is going to say, we got this ruling from the Supreme Court 3 years earlier. This is what they said. So we're just going to reject your case sort of on the principle that we already have a decision on this topic made. Now that doesn't necessarily 100% mean the Circuit Court will always fall in line with the Supreme Court. They have to, though, deal with the previous Supreme Court decisions and explain why they're wrong or why times have changed or something to that effect. So if you're a Supreme Court or a U.S. Circuit Court justice looking at Loving v. Virginia, which is the court case that made interracial marriage legal all around the country, the Supreme Court had previously ruled that such bans were okay. If you're a circuit court and you want to overturn that opinion, the deck is kind of stacked against you already. You've got to really show that times have changed, that this is a dumb law, that the Supreme Court was wrong, etc. If you want to overturn the decision and then or rule differently than the Supreme Court, the Supreme Court will hear the decision or will then hear the case, and the Supreme Court will have to deal with previous case law on this issue. So in Loving v. Virginia, they talked about a case, Pace v. Alabama, that happened in the 1880s, where a black man and white woman, I think was the direction that went, were caught having sex with each other. I think it was in a bar. Excuse me. Anyway, caught having sex. They're both sentenced to a year of hard labor. The Supreme Court ruled that such a thing was constitutional because, and this is the Supreme Court's reasoning, the law was applied equally to both the white person and the black person. Therefore, it didn't treat anybody differently. It didn't violate anybody's rights because that's the law, and everybody's equally enforced by it. Um, but now, obviously, we're glad that such precedents are not set in stone, that you can change them. It's important to know that you can change precedents. However, you have to deal with them in a court case. One key fact that I like to make sure people know is that most of the arguments delivered to the court are delivered in written form, not in oral form. We generally have this idea of of lawyers going before a judge or a whole panel of judges or justices and saying, these are the facts of the case, this is what you should decide, my argument's right, etc., etc., etc. Well, at the Supreme Court, you give the court lots of evidence before you have your case heard. You give them lots of written legal opinion, commentary on previous case law and why it applies or it doesn't apply, expert opinion if needed, etc., etc. Then you have an oral argument part of the case, but that only lasts about 30 minutes per side. Sometimes the court will make it last considerably longer if the case is especially complex, but the oral argument portion takes about, the 30 minutes that each side gets to say something at the justices, and the justices get to ask the lawyer questions about what they've written to them. So that's that. Oral arguments are a small part of a Supreme Court case. Now, just a couple of comments on justices and the current Supreme Court. So the Chief Justice is the head of the Supreme Court, and the court is known for who the Chief Justice is. John Roberts is the current Chief Justice of the Supreme Court, and the court is known as the Roberts Court. The Chief Justices have a sort of special interest in making sure their rulings are, at least can be seen as non-partial, or they're not prejudging cases, they're not being ideological in how they're judging cases, because the Chief Justice's name is going to be the one that's attached to all these rulings, or to the history of the court. So this is the Roberts Court. Whenever we think of the ACA ruling, the Voting Rights Act ruling, the Citizens United ruling, the Hobby Lobby ruling, we're going to be thinking of John Roberts and the Roberts Court making these decisions. And we're going to think of John Roberts as having one of the more conservative courts in American history. At least it seems that way so far. John Roberts, therefore, has a kind of vested interest in doing something that makes the court not seem completely predictable and split along predictable ideological lines. So he'll try and mix it up a little bit. There's another aspect to this mixing it up a little bit. If the court, and this is a really strange way to kind of judge impartiality, if you ask me, but if the court makes a proper mix of decisions favoring one side or another, then the court can create this air of impartiality, which can make the court's decision seem legitimate, to make the institution seem more legitimate. That's been a big concern for the Supreme Court over its history, is it wants to make sure that people follow its rules, take it seriously, It's one of the more it's the branch of government where it's probably most important. Um, um, where how people see the court is most important. The Congress will be able to do things and will maintain authority to make decisions, even if it's seen as a complete corrupt wasteland. The Supreme Court, on the other hand, because it doesn't have the same sort of like power base, it can suffer from not being viewed as credible, as impartial, etc. So there's also some bias in the court towards trying to mix up its decisions a little bit. Anyway, so justices are, they're people, they're not aliens, and they make decisions based upon the fact that they're people. They will look at the law, the legislative history of a law, meaning why did the law come into being, what were the arguments made for the law, what amendments were in the law before it was passed, and which amendments were taken out of the law. All those things as clues as to what the original legislative intent of a law was. They'll look at that in a rational sense, so theoretically at least. They'll look at what the Constitution says. They'll look at what freedoms and rights people have. They'll look at previous case history. Those are things that we kind of all expect the Supreme Court to look at. And we at least imagine in a perfect world, we meaning the public, not necessarily any one individual. Public believes that's all the Supreme Court should consider, and that it can consider that in some sort of independent, impartial fashion. If you think that, you're super naive. I'm sorry, but you're super naive. Justices are people, and they have things like morality and religion, and they have experiences, and they have different upbringings. They maybe can sometimes come from different socioeconomic statuses, and all this can lead people to come to different conclusions, to see a problem in a different way, which is why everybody has a bias, and there's no such thing as being unbiased. BTW, relating this to like the first week in class. And these are all things that the court will factor into their decision as well. I think it was Alito that said something along the lines of, Alito is one of the conservative justices, he's a white male, said something along the lines of, well, racial discrimination isn't an issue anymore today. Sonia Sotomayor, the Obama appointee who is a woman and Latina, apparently in very dramatic fashion, turned to him, stared him down across the court bench, and I'll paraphrase here, "Are you fucking serious?" is what she said, but in like justice speak. I'm just translating it for you so you can understand what she said and how like forceful she said it. Alito is a white male, hasn't had that experience of discrimination, is in a position of privilege where sort of everything is looked at as being the white male is the norm, and so as a white male you don't have to consider anything's effect on anybody else, because laws, the media, life, is centered around your perspective, and your perspective becomes normalized. And as white males, it's especially difficult for you to realize that other people who are not white males may see this situation differently because they're on the outside, and they can see how the laws that are being passed, how the media is biased towards your point of view. And Sotomayor called that out on Alito in that court case, and it was pretty awesome. And it, Alito showed some emotion there, and Sotomayor showed some emotion there about how close this racial justice case was, hitting home for them. And that's okay, because humans have emotions and they make decisions based upon them. So the current makeup of the Supreme Court, by no fault of its own, by accident, by the random convergence of when people retire and die. Right now we have 4 liberal members on the court. The liberal voting bloc, they generally all vote together. We have the conservative members of the court. They all tend to vote together. And then we have one justice who's conservative leaning. Conservative leaning means he's like, he could go either way on a case. Generally, you would think of him as maybe being a swing voter. However, he's definitely conservative, or he leans towards the conservative end. He'll vote more often with the conservatives on the court than the liberals. So on a lot of really divisive cases, you have 5 justices that have voted for like whatever the conservative solution is, and you have 4 justices that have voted for whatever the liberal position or solution is. So that's how that works. It's important to know that breakdown of what it is right now. And when we look towards justices that are getting like super old and might retire or maybe die, you're looking at Scalia, who's a conservative. You got Anthony Kennedy, who's a conservative leaning person. You got Ruth Bader Ginsburg, who's the most liberal member of the Supreme Court. She was appointed by Clinton. She was a former ACLU lawyer. So conservatives would really like to see her gone. Stephen Breyer, another liberal member of the court, I did not know this, 76 years old. So he's starting to get up there, and I think Clarence Thomas is in his 60s. I'm going to check that out. Yeah, he's 66, so he likely has another decade or 2 in him. Where's Antonin Scalia? He should be in his 70s. Yeah, he's 78. He's got, the average lifespan of a Supreme Court justice is longer than like us normal people's lifespans. But Scalia 78, Breyer is, 78 or 77. Gins is 81, so she's might be on the way out the door at some point. That's right, Kennedy. Anthony Kennedy is 78. So you have Scalia, Kennedy, Ginsburg, and Breyer, who are all within 4 years of, or 3 years of 80 years old. 2 conservatives and 2 liberals. If one of them, if either one of the conservative goes before Obama gets out of the presidency, we'll have another Democrat. If a Democrat's elected president in 2016, we'll likely see at least one or two additional Supreme Court nominees. That would at least replace one, if not both, Kennedy and Scalia. That'd be my prediction anyway. Here's the thing, though, about the Supreme Court. The Supreme Court has taken a very significant conservative turn over the past several years, 30 years. 2 reasons for that. One, Republicans have been in office a little longer than Democrats. 1980? You have 12 years of Reagan and Bush. So it's 12, let's say. Then you had 8 years of Clinton. Then you had 8 years of Bush, which is now 20 years that Republicans have been in the office. Now we've had 6 years of Obama. So 20 years for Republicans to make nominees, 14 years for Democrats. So they've had more chances to put people into the judicial branch or to the Supreme Court. The other important thing is the Republicans have moved way, way to the right since the late 1970s. It really, Democrat Carter kind of helped move the country more and more to the right. But Reagan came in and put Carter's somewhat rightward tilt on overload, and then Clinton continued Reagan's further right policies as a quote-unquote new Democrat, his third way politics, which was essentially somewhere between Carter, I guess kind of Carter liberal, maybe between Carter and Reagan liberal, definitely not as liberal as Nixon. So Clinton and Gore are these very conservative Democrats, and then you have Bush, who's at that point the most conservative president we've had, and then, or at least modern president we've had. And now we have Obama, who's actually a little bit more liberal than Clinton, I would say, but he essentially has surrounded himself with Clinton's old advisors. As both the Republican parties and Democratic parties have moved further to the right, that means that their judicial nominees have moved further to the right. So even though we've essentially, for Obama, replaced 2 liberal members of the court with 2 more liberal members of the court, the thing is, the liberal members of the court he was replacing were more liberal than the ones he replaced them with. So you have 2 super duper liberals on the court, they leave, and you replace them with 2 liberals. Which means, even though you maintain the liberal balance in numbers games, the court still takes a rightward shift, because you go from 2 super liberals to 2 liberals, moving the whole center of gravity on the court further to the right. If that makes any sense. That's why, for example, if Ruth Bader Ginsburg goes, when Obama appoints somebody to replace her, more than likely he is going to replace her with somebody who is not as liberal as her, and the court will make an even further rightward shift. But he doesn't have to run for re-election. Maybe the Democrats will hold on to the Senate. So maybe he'll go all out and replace Ruth Bader Ginsburg with Super Ruth Bader Ginsburg. You never know. So that's the ideological breakdown. We've talked about what a court takes into account. Look at what slide 13. The power to interpret laws, what they look at, legislative history, previous case law, words of the law itself. And remember this idea that when you lose a case, you accuse the justices of being activist justices, which I guess is a bad thing. I think activists are generally, it's good to be an activist. It means you care and you're, involved in your community. But when you're a judge, I guess it's not good to be an activist. So if you lose, you yell activist judge, damn those activist judges. Or you could yell, those just judges are legislating from the bench and not letting democracy, do its thing because they're overturning the will of the people. Darn it. So that's when that happens. The key terms on the last 2 pages, again, familiar self with them in the back of the book. I highly recommend it because it'll be useful for you, if you care about your success in life. It's useful for you to know these terms. We will be adding more of these terms to our vocabulary as the semester goes on. So it's always useful to get a head start. But I suppose most of you just, care about learning, of course, right? And are super interested in American government. And you're mad at me because there's not a 3rd page of terms there, so that you don't have more things to learn. I apologize. And I will work on correcting that deficiency in both my dedication to educating you all and in my character as well. But since we only have these 2 pages of terms here, look at some of the terms we've gone over. We talked briefly about the plaintiffs and defendants, the Court of Appeals, appellate courts. Appellate courts are the courts that you appeal decisions to. We know what jurisdiction is. We talked about briefs, which are the underwear that justices wear, that provide them with the magic power to channel the founders of the nation and to discern their original intent. That's a joke. Briefs are actually those written arguments I talked about, that where most court opinions are heard. Amicus briefs are briefs filed by people that are not directly members of the case but have expertise to lend to the court. We'll talk a little bit more about that later. They're pretty awesome. I would love to write an amicus brief one day. Judicial review is the power for the court to render things unconstitutional, to review laws if their laws are constitutional or not, if the government agency is carrying out a law correctly. We have opinions, majority and minority opinions, if you can believe this. The majority opinions are the opinion on a case written by the majority of the voters or the majority of the justices on a case. So if a case before the Supreme Court is decided 6-3, the majority opinion is going to be written by the side that had 6 people agreeing there, because they're the majority. The dissenting opinion, which may also be called the minority opinion, but generally we think of it as the dissenting opinion, is the opinion written by the 3 justices that disagreed with the majority. And we did talk about in class, I haven't mentioned it yet here, stay of a ruling. To stay a ruling, what will often happen is if a district court or a circuit court makes a very significant ruling that can have very drastic social or economic consequences to it, and you know that the case is going to be appealed, or one of the sides states their intent to appeal the ruling, that court may decide to stay their own ruling. If they don't decide to stay their own ruling, then the Court of Appeal may quickly look at it and decide if the lower court opinion will be stayed until the upper court rules on that case. To stay a ruling essentially means, listen, this is the opinion, this is the law, however, it's not going to go into effect until some additional condition is met. Generally, it's the higher court that rules on the appeal. So the U.S. District, or the U.S. District Court, this is an example of what happened. So I think, so the U.S. District Court in Virginia ruled that gay marriage is constitutional and gay marriages must be allowed and recognized in Virginia. However, that ruling has been stayed, which means that ruling has not gone into effect. If that ruling had gone into effect, people would be able to get married in Virginia, gaily married, gay and lesbian individuals would be able to get married in Virginia at this moment. However, either the federal district judge or the circuit court judge decided to stay that ruling, so it wouldn't go into effect. Because if it did not go into effect, or because if it did go into effect and the Fourth Circuit Court overturned the ruling, you'd have the situation where a lot of people would be married in a state where marriage is technically illegal. So, are those people that got married, are they still legally married, or are they not legally married now? It's a big question. It's a legal issue that's messy to sort out, so it's easier just to stay a ruling if you know it's going to be appealed to avoid that messiness. This did happen in Utah for about 36-ish hours. A federal district court ruled that gay marriages were legal in Utah. The people that lost the case, that wanted to keep gay marriages illegal in Utah, asked the district court to stay his ruling, to make it not go into effect. The district court judge in Utah said, hell no, these people have constitutional rights, they're getting married. 36, maybe 72 hours later at the most, the Ninth Circuit Court decided that they were going to take up the case, it's the 10th Circuit Court is what Utah's in. The 10th Circuit Court decided that they were going to take up the case, make a ruling on whether or not the district judge made the right decision, and they then stayed the ruling of the district judge, meaning they made it so that law was not into effect, or that decision was not put into effect, and gay marriage is now still illegal in Utah pending the ruling of the 10th Circuit Court. Now, during the time between when the district court ruled and the 10th Circuit Court could stay the district court's ruling, I think about 1,400 couples got married. Gay couples got married in Utah. So now there's this big question as to what is the legal status of those gay couples. They were married when it was briefly legal, but the court has stayed the ruling, so are they still married? Are they not married? It's a question that people have to figure out. But that's the type of issue that can come up in the wonderful wide world of courts, which is super fun, and everybody loves reading the opinions, and you'll get to read some soon. Yippee. Okay, so that's that. Talk to you later. Bye.